Good afternoon. My name is El-Amin. I live in Richmond, Virginia. I recently filed a lawsuit in the United States District Court here in Richmond, Virginia, in which I am challenging the disenfranchisement of persons like myself who have been convicted of a felony and because of that conviction no longer have the right to vote and hold office. My suit is dedicated to the late Senator Yvonne Miller, who died on July 3rd of this year. Senator Miller was the first black woman elected to the House of Representatives and State Senate, and she later became the first chair of a standing committee. Senator Miller was a longtime advocate for the restoration of the voting rights of ex-felons, and she was unsuccessful in this attempt even this year because of staunch opposition by both Democrat and Republicans in the General Assembly. There are almost 400,000 convicted felons who live in this state who have been stripped of our right to vote and hold public office, yet we're still burdened with the duties of citizenship, such as obeying the law. We have become effectively stateless persons because we do not enjoy the privileges of being a citizen. And our statelessness is not because of the judgment or sentence rendered against us by a court, but because white people, early in the formation of this state, employed racially discriminatory tactics and legal proceedings to deprive us of our right to vote and hold office. And that is not only including those convicted of felonies, but black people in general. And it wasn't until the Voting Rights Act of 1965 that the state of Virginia was put under certain restrictions and observations to curtail their incessant attempt to keep us from voting and holding office. My suit challenges Article 2, Section 1 of the Virginia Constitution, which reads, open quote, no person who has been convicted of a felony shall be qualified to vote unless his civil rights have been restored by the governor or other appropriate authority. This is my legal challenge. And the challenge is based upon two legal theories. The first is that because of the predominant number of African Americans who are convicted of felonies in the state of Virginia versus all others, that this prohibition violates the equal protection of the law based on race. The other aspect is that when the Constitution of Virginia was passed in 1870, there was a requirement that the state prohibit two classes of people from voting: people convicted of felonies and those who rebelled against the United States. In other words, Confederates who fought in the Civil War were required under the 14th Amendment, Sections 2 and 3, from being able to vote and being able to hold office. However, the whites in Virginia decided to ignore the prohibition against Confederates, and they continued to vote and hold office, and they only enforced that provision of the 14th Amendment against convicted felons, the majority of whom were African Americans. So we argue in the suit that this intentional enforcement of the law only to people of color, for the most part, and allowing whites who were the majority of those who fought in the Civil War, allowing them to vote, is a classic example of the denial of equal protection. The second part of the lawsuit, which we think has strong legal merit, is that the history of Virginia is full of attempts by whites to repress and suppress the black vote. We quote from early 1900s when a Virginia senator by the name of Carter Glass, who was a delegate from the city of Lynchburg, Virginia, how appropriate, Lynchburg, Virginia, was quoted as saying that the overall approach of the Constitution and in 1901 was to reduce the black vote, because despite the 15th Amendment of the Constitution of the United States, which gave us the right to vote, that is, gave black men the right to vote, and this was done even when white women were not allowed to vote, and of course black women were not allowed to vote. But we have a history in this state of suppression of the black vote through such things as poll taxes, literacy tests, and grandfather clauses. Let me read you from the Constitution in General Assembly that was enacted in 1904 that restricted the right to vote only to men who had paid a poll tax of $150 for each of the 3 preceding years, which exempted Civil War veterans, people who made application to the registrar unassisted and in their own handwriting, and those who provided satisfactory answers to any questions that the registrar asked. Well, the registrars clearly was seeking, all of whom were white, to disenfranchise or keep black people from voting. So they would ask insane questions that only a college graduate might know. But when it came to whites, they rarely asked them any questions, and they were presumed to be intelligent, and so they were allowed to vote. Well, there's a Supreme Court of the United States decision made in 1985 which holds that where a state has a history of suppression of the black vote, that history will be allowed to be seen today and used by plaintiffs in a lawsuit who claim that their rights today are being denied because of the history of the suppression of the black vote. There is no question that Virginia has a rich and infamous history of suppressing the black vote, and so therefore I feel that I can successfully challenge the disenfranchisement of myself and other ex-felons because of this Supreme Court decision. Now I want you to imagine something. If 400,000 people were suddenly allowed to vote as a result of my lawsuit, it would change the political landscape in the state of Virginia, because Virginia is one of the so-called battleground states for the upcoming 2012 presidential election. Because a vast majority of those who would be able to vote if my suit was successful would vote for President Obama, because a vast majority of those who are not allowed to vote are African Americans. So this suit not only has a practical effect of allowing the people who have been disenfranchised by virtue of the Constitution of the of Virginia to be allowed to vote, but the net effect would be to radically change the voting platform and the voting scenario in the state of Virginia. And so I'm asking you for your prayers and your financial support. I'm going up against the state of Virginia. I'm going up against the Attorney General, who has the largest law firm in the state of Virginia. And I'm going up against the Republican Party because the Attorney General is a Republican. Now, there was obviously David against Goliath, but David had smooth stones, and he was able to use those against Goliath. So I need your financial support. And on this website is a donate button. I ask you to be generous, to hit that button and make a contribution to this case. And any monies that are surplus beyond that which is needed for this lawsuit, I promise you, will be used to continue the fight for freedom, justice, and equality, and to continue to move our people forward in terms of their civil and human rights. So I ask for your support, I ask for your prayers, and I ask for your thoughts. Thank you, and have a good day.